Well, hello. How are you doing? I'm having a good evening. I hope you're having a good evening too. I am Uncivil Law, and we are here with more Uncivil tea. Because that's what you guys crave. As the plants crave electrolytes, you crave tea. And I'm here with your tea-related needs. The West India Company's got nothing on me. So we are here with a response from Without a Crystal Ball. In the motion to dismiss, well, technically it's a reply. We're here with a reply from Without a Crystal Ball. In the motion to dismiss stuff, we got a new declaration. We got some other things. Super fun. We're going to read it. I have not read it. We're going to read it and see what it has to say. And if it changes our mind at all. When we last left the action, we thought that Toddy had a pretty good argument for keeping the case in the Washington courts. We thought that based on the case law as we then understood it, that there was sufficient availment by Katie in Washington, not only of the members and subscribers, which kind of seemed a little thin to me, but more to the point, the getting the many documents and the fact that she was aware of the business being in Washington and defamed them and such and so forth. So that seemed like there was enough to meet minimal contacts. But I was not particularly confident, even though I thought it was extremely likely, because it's not an area of law that I'm familiar with as some. And so I'm prepared to have my opinion changed and revised. So we'll see if that happens. We'll see if Katie's lawyer makes arguments that beat Salt's. It could happen. It could happen. We'll try to give it a fair reading and see what happens. And we'll go from there and see if any of it makes sense. Fun. And also, on just a personal note, as you may or may not have noticed, I have a new lens for my camera. So, hey, new lens, even sharper, even better. We're making improvements for you. All right, let us do this. We have 3 documents that we're going to review and see what they have to teach us. And of course, as always, we will give the standard disclaimers, right? This is written by Katie, right? So we interpret it against Katie, right? Because it's meant to look in the best possible light, so we look for weaknesses in the argument against Katie. She's trying to make herself look good, and we'll, go from there. Fun. Yeah, I have a green screen. I have a green screen. I just have nothing to put on it right now. We've been playing with the green screen, but we have it. I just don't know what to put. I've been playing with different backgrounds, and I just haven't found anything I like. Cheers. Love the new lens. Thank you. That's awesome. Look, we've looked at many possibilities. We've looked at walls of books, we've looked at libraries, we've looked at lots of different things. And I just haven't found anything that I particularly like. I'm really picky on this, I guess. The reality background is working better than we've tried on the batch records using a background, but we're working on it. We have a green screen, it works great. Oh, what am I drinking? Oh, that's a very good question. It's a very nice bourbon today, actually. Blackland, Texas Pecan, Brown Sugar Bourbon. Yes. Bourbon whiskey with brown sugar and pecan. The Blackland Prairie runs from Red River to the north down by San Antonio on the south. Lightning fire cleared this land for native tall grass to thrive in the rich, dark soil. Made in Fort Worth. And it's very good. All right, so let's read this and see what it has to teach us. What shall we learn? The defendant's reply in motion to dismiss. Yeah. Yeah, if Blacklands would like to sponsor me, that'd be great. Because I really enjoy it. Plaintiffs fail to demonstrate a basis to assert personal jurisdiction over defendants. Okay, let's figure out if we agree if that's correct or not. Plaintiffs fail to demonstrate that defendants purposefully directed their conduct at Washington under the effects test. In cases alleging intentional torts, where the alleged tortious conduct takes place outside the forum and has effects inside the forum, the Ninth Circuit examines purposeful direction using an effects test based on Caldeira. Caldeira is the dominant case in this area at this time. So, yeah, that's the right case. This test has three elements. The defendant allegedly must have committed an intentional act expressly aimed at the forum state, causing harm the defendant knows is likely to be suffered in the forum state. So, we have to commit an intentional act, which we're already there in the first place because we're doing an intentional tort as opposed to negligence, right? So, we're doing it on purpose. That's intentional. So we're kind of there implicitly. So expressly aimed at the foreign state. We're trying to aim it at the foreign state and causing harm. Defendant knows or should know, probably, is likely to be suffered in the foreign state. So was it aimed at Washington? Did the harm occur and she knew it would occur in Washington? There seems to be some evidence that would suggest that. Defendants concede that they are alleged to have committed intentional acts. Yeah, that's right, because defamation in this context would be an intentional tort. Fine. However, plaintiffs fail to allege or present evidence the defendants expressly aimed their conduct at Washington. All right. As explained below, the plaintiffs make no attempt to establish the focus of the alleged harm was Washington. That doesn't seem like the correct statement of the law. It's not focus. That's wrong, because focus implies a particular effort at this state as opposed to other states. You can expressly aim at multiple states, so I don't think focus is the right word. The focus of alleged harm was in Washington, and the contexts they do identify are plainly insufficient to establish express aiming. Okay, fair. That could work. Plaintiffs make no attempt to show Washington was the focus of the alleged harm. The focus or brunt of the harm remains the critical factor. I don't believe the Ninth Circuit uses the brunt of the harm test. Plaintiff's effect express aiming argument is most notable for its failure to even attempt to show the alleged harm from defendant's publication was focused in Washington, or even a substantial amount of harm was suffered here. I don't know. There seems to be a substantial amount of harm that was suffered in Washington. This omission appears to be explained by plaintiff's overreading of the Ninth Circuit 2006 holding in Yahoo. Prior to Yahoo, the Ninth Circuit has sometimes stated the third element of the effects test, foreseeable harm in the forum, as requiring that the defendant's conduct have caused harm, the brunt of which, that was the old standard, the brunt, which also seems like focus. The brunt of which is suffered and the defendant knows is likely to be suffered in the forum state. In Yahoo, the court clarified that the third element contains no such requirement. In some of our cases, we've employed a slightly different formulation of the third requirement, specifying the act must have caused harm, the brunt of which is suffered and which the defendant knows is likely to be suffered in the forum. We take this opportunity to clarify our law and state that brunt of harm need not be suffered in the forum state. So it is sufficient, but not necessary. Instead, the court held the third element required only the plaintiff have suffered a jurisdictionally sufficient amount of harm in the forum. Yeah, I think that's perfectly fair. So far, so good. We're doing better on this so far. Where were you in your prior filing, man? So far, we're off to a really good start. Contrary to plaintiff's suggestion, Yahoo did not remove the brunt of the harm from the purposeful direction test. Interesting. Interesting. That's a very interesting read. Okay. That's a challenging read of the law. I don't think he's right, but he's making a very credible legal argument. All right. So here's what he's saying and why I'm spending a minute thinking about it, because I had to think about it, which tells you it's a pretty good argument. I actually had to think. All right. So he's saying there's this 3-factor test. So the 3-factor test will go back up. The 3-factor test is you have to have committed an intentional act. It has to be expressly aimed at the foreign state and causes harm the defendant knows is likely to be suffered in the foreign state. So those are the 3 things you need for jurisdiction here. The intentional act aimed at the state, you knew it would cause harm in the state. All right. Then he says, there's this language from this case called Yahoo, which is controlling authority. And this case, Yahoo, has this sentence in it. It says, we take this opportunity to clarify our law and to state that the brunt of the harm need not be suffered in the foreign state. Now, you could read that as being a global statement, right? That is just globally true. You don't need to have that at all, right? So our law does not require this element. Now he's saying that's the way that Saltz has read it. That's the way Saltz has read it. He's read it globally, that you do not need to show brunt of harm, period. That's the way Saltz reads it. What he's saying is that actually, no, that's a mistake. The court was only saying that's not a required element for the 3rd element, not all the elements. So brunt of the harm could still be required as a 2nd element, just not as the 3rd element. So that's what he's trying to do. He's trying to say the correct way to read this case is not that brunt of the harm is not required at all, just that it's not required for the 3rd element. But it might be required for the 1st element and might be required for the 2nd element. So he's trying to narrow the scope of this sentence. Okay. I know. I don't think that's right, but it's a plausible legal argument. Instead, the court held the 3rd element required only the plaintiff suffered a jurisdictionally significant amount of harm. So the 3rd element does not require brunt, but maybe the 1st or 2nd does. Clever. We're off to a much better start than we were before. Contrary to plaintiff's suggestion, Yahoo did not remove brunt of harm factor from the purposeful direction effect test. It only clarified that it was not required under the 3rd element. So he's saying Saltz is overreading the case. Okay. Then he cites this case from 2010, Brayton Purcell, that says, it says, observing that Yahoo clarified that the final element of the effects test did not require brunt of the harm. Hey, he's trying. Recent Ninth Circuit rulings make clear that in cases involving allegedly tortious publications arriving in the forum from outside the forum, the focus of the harm test remains highly relevant, indeed potentially dispositive, to the 2nd prong of the effects test, expressly aiming. Okay. And then he says, notably, plaintiffs analyzed purposeful direction for these intent-based claims based exclusively on Caldera and Keaton, both decided in 84, years before the internet came into being. I'm not sure how meaningful that argument is unless we develop it. Sometimes we do cite cases from 1984 or 1884 or 1784 or 1684. So I'm not sure that's necessarily a blow against it, but okay. In Axiom Foods, the court held that express aiming at California was not shown where the non-resident defendant emailed an alleged copyright infringing newsletter to 434 persons, 10 of whom were in California. So the fact that I had this is basically going to the fact that I had subscribers in Washington is interesting and all. It's just that I have subscribers everywhere. So it was not differentiated in any way. It wasn't aimed at Washington. It wasn't targeted. I had subscribers there. I had revenue from there. I just wasn't trying to get them from Washington specifically, which, I totally believe. Why would she want people from Washington specifically? Presumably she would be equally happy with anyone watching her content from anywhere. Doesn't really matter. It's all the same to her, I would think. I mean, I don't know what's in her brain, but there's no particular reason to want people from Washington State watching it, I guess. Applying Caldeer as most recently interpreted in Walden, it reasoned that the express aiming requirement was not satisfied because most of the recipients of the newsletter were outside the forum. As such, unlike Caldeer, California was not the focal point, both of the letter and the harm it suffered. He's making pretty good arguments. This is the direction I thought that he should be going. If you listen to my earlier stream, this is the direction I thought he should be going. Basically arguing that the Washington stuff was undifferentiated. So he's going along the line that I thought he should go. So maybe that's why I think it's particularly good, because this is the direction I thought he should go. So he's going the direction I thought he should go. So therefore it must be brilliant, right? Maybe he's taking notes. That's fine. Similarly, in AMA Multimedia, the court held that purposeful direction was not established over a publisher of internet pornography, that customers in the forum state represented nearly 20% of its audience. Indeed, the court rejected the assertion of personal jurisdiction despite additional significant connections between defendant and the forum, including a substantial amount of defendant's content was developed within the forum, and the defendant used a forum-based company to facilitate the use of the website. The court concluded that the express aiming requirement was not satisfied because the forum was not the focal point of the website and the harm it suffered. That's a lucid, cogent legal argument. Most recently in Janus, from the Ninth Circuit, the court applied Caldeer and Walden to hold that express aiming was not established with respect to defamation and harassment claims arising from social media posts the defendant had deliberately sent exclusively to California residents. Interesting. In Janus, the court applied Caldeer and Walden to hold that express aiming was not established with respect to defamation and harassment arising from social media posts defendant had deliberately sent exclusively to several California residents. Okay. It reasoned that, those connections notwithstanding, the plaintiffs had failed to show the brunt of the energy. So he's trying to bring this brunt aspect back. In sharp contrast to Caldeer, in which defendants caused reputational injury in California by writing an allegedly libelous article that was widely circulated in the state and in which the brunt of the injury was suffered in that state. Okay. Janus relies on only a handful of communications that Freeman made at most to a few Californians. And there's no evidence or even allegation those communications had reputation-based effects of the sort that's sufficient to warrant hauling Freeman in the court. So you're kind of like halfway there, right? So in this case, there wasn't targeting, at least the way that he's summarizing it, there wasn't targeting and there wasn't harm. Here, I think that there's pretty well harm, but they're still going to say the targeting wasn't there because there's nothing differentiated about it. He's making the right argument. Good work, counselor. Because plaintiff's showing with respect to reputational injury in California was so weak, the court concluded the plaintiff had only demonstrated an Antonian affiliation with the forum. Are they implying some sort of sliding scale analysis between harm and affiliation in that language. So the more harm, the less affiliation or something. Are they implying some sort of sliding scale in that language? To establish harm occurring in Washington, plans rely solely on declarations of 2 Washingtonians who attest they stopped purchasing Halo products after watching the videos, because the videos cause them to think less well of plaintiffs. Importantly, this is 2 out of hundreds of thousands, if not millions, of viewers. Undifferentiated harm. Yeah. They're alleged to have watched these videos. Even taking these declarations at face value, they come nowhere close to supporting assertion of personal jurisdiction. See, for example, Janice contrasting the receipt of publications of a few Californians insufficient to establish aiming to the 600,000 copies of National Enquirer circulated that led to the brunt of the injury. Nice. I like it. I like it. See Axiom Foods. Receipt of allegedly infringing newsletter sent deliberately to 10 Californians out of 343 recipients insufficient to establish express aiming. AMA Multimedia. Express aiming not established where 20% of defendants' internet audience was located in the forum because that was insufficient focus to show the forum was the focal point of harm. If forum harm ratios of 3 and 20% are insufficient to establish focus, certainly the ratio here means the harm of forum is virtually non-existent. And there's no particular reason to believe that 20% of her viewers are from Washington. I mean, I wouldn't know, but there's no particular reason to believe that in the abstract. So, yeah, pretty good. I like it. I like it quite a lot. Good authority. Good argument. Plaintiffs continue to insist they're residents of Washington beginning late 2018. As explained in Section 2 below, that assertion is conclusively refuted by Mr. Westbrook's own sworn declaration in 2019 and another lawsuit that he was living in lawsuit in California as late as 2019, as well as trove of other evidence. Did Mr. Westbrook say that they were living in California until late 2019? That would be a way of pointing out inconsistencies from Toddy's side of the argument. Some potential fibbing. However, as defendants explained in their opening brief, even if, and to the extent, plaintiff lived in Washington at the time of the alleged defamatory publication, and even if defendants were aware of that, it would not support public personal jurisdiction. Okay. In Walden, the court expressly rejected the view that Calder effects test is satisfied merely because of the commission of intentional tort that's aimed at a person known to be a resident of the foreign state. That makes sense. Yeah, I buy that. Okay. Yeah, I buy that. I still think that the liability for the business is more promising than for Toddy or James, but in Calder, the court held that California court could exercise personal jurisdiction over non-resident journalists, in part because they deliberately reached out to make telephone contact with persons within California in the process of sourcing their alleged defamatory story. As such, they intentionally directed the conduct at the forum state itself. Okay. Plaintiffs do not even allege defendants contacted any Washingtonian in the process of preparing their stories. Instead, they argue defendants use Washington sources within the meaning of Calder, mainly by using general websites that collect information from all 50 states and post electronic records. So they didn't get the records from Washington. They got the record from third-party sites. So they didn't pull court records from Washington. They pulled it from a third-party site, which could be based anywhere. That's good. While in Minnesota, defendant accessed and searched Ancestry.com and MyLife.com. Both of them are globally available websites that collect records and information from all over the United States. Defendant were not searching for Washington records. They were instead seeking information regarding the Westbrooks from whatever source they originated. Yeah. Indeed, plaintiffs admit this when they argue defendant researched everything and everywhere. Yeah. What cuts for one, so that helps. The plaintiffs argue that which helps for the civil harassment, but cuts against another factor somewhere else. So not everything splits cleanly for one side or the other. So by researching everything everywhere, it increases the civil harassment problem, but it also reduces the targeting for personal jurisdiction. So things cut both ways sometimes, right? It so happened the results of the search included electronic records from Washington, as well as from North Carolina, South Carolina, Nevada, Hawaii, and California. Those images have been retrieved and stored by someone other defendant on the website servers. Defendants did not purposely direct or expressly end their contact at Washington by accessing those websites any more than had they logged into Amazon.com to purchase a book. I like it. I like it quite a lot. That is a very solid argument. I didn't actually access any records from Washington. I accessed them from Ancestry.com and wherever else. And so I didn't avail myself of Washington. I didn't call any sources in Washington. I don't do things in Washington. I do things on Ancestry. That's where I found all the records ever. I like it. I like it quite a lot. Purposeful direction is not established by defendant's alleged receipt of negligible income from a negligible audience. Again, this is exactly where I thought he should be going. This is exactly the argument I thought he should make. The Washington stuff is undifferentiated. Yeah, we had subscribers in Washington. Sure. We had super chats from people in Washington. People tell us they're in Washington. People tell us they're from everywhere. So it's undifferentiated. It's not special. This is exactly the argument I thought he should be making. Good job, counselor. Plaintiffs contend the defendant had a Washington audience, were aware of its existence, and knowingly earned money. But the only evidence they support in support of the statements establish at most that 2 Washingtonians viewed the alleged defamatory publications, 3 Washingtonians viewed different videos that are not alleged to be in connection with this case, and 1 Washingtonian subscribed to the defendant's YouTube channel. This showing is feeble by any measure, but it's especially so when measured against plaintiff's assertion that the alleged defamatory videos were viewed by hundreds of thousands, if not millions of people. Indeed, in Caldera and Keaton, the alleged defamatory publications reached a forum audience of 600,000 in Caldera and between 50,000 and 75,000 in Keaton. Note in Caldera was based in part on the circulation numbers of National Enquirer. Some footnotes here. I'm just trying to see if the footnotes have anything interesting to say. In AMA, the Ninth Circuit found it insufficient that a significant portion of the website content was generated from within the forum because they did not show conduct was aimed at the forum. That being the case, defendants' publications include some historical facts derived from Washington records cannot be aimed at Washington. That's a fair point. Just because I got records from Washington doesn't mean I was aiming my video at Washington. Those two things are disconnected. I mean, that's completely true. Just because I got records from wherever doesn't mean I was aiming my video at where those records came from. That just happened to be where I got my information from. That's right. Plaintiffs do not even argue the videos had anything to do with the lawsuit or with them at all. Further, defendants received literally hundreds of these chats every time they broadcast videos. Yeah, right on the money. It's entirely irrelevant that a few Washington residents and a few unrelated videos decided on their own to reach out to chat. Right on the money. Undifferentiated. There's nothing special about it. Plaintiffs rely on Mr. Westbrook's own declaration as support for the argument. Defendants derived income from all views within Washington of alleged defamatory conduct. But Mr. Westbrook provides no foundation for his alleged expertise and no basis for applying it to defense revenue from Washington or anywhere else. I'm not exactly sure what that footnote's supposed to be doing, but okay, that's fine. In addition to failing to come anywhere close to the bar set by Caldera and Keaton, plaintiff's argument is foreclosed by Ninth Circuit's very recent holding in AMA Multimedia. That express aiming was not established where 20% of defendant's audience was inside the forum. The court reasoned there was no showing defendant had specifically targeted the forum, as opposed to generally circuiting and promoting its website in a manner that would necessarily lead to garnering its audience and customers there. Yeah, I mean, that's right. Right on the money. Good job. Where was this lawyer in the motion to dismiss? Where was this lawyer in the motion to dismiss? That's all I want to know right about now. You know. Man. The court reason is no showing defendant had specifically targeted the forum as opposed to generally targeting. The same is true here, but even more so. There's no evidence defendant had a Washington audience anywhere near 20% of their total audience. See the supplemental declaration. So there's a supplemental declaration where they actually looked into their analytics, apparently. We'll get to that. We haven't gone that far yet because that's a later document. But apparently they're going to swear that Washingtonians make up 0.07% of their subscribers. We'll get to that later. But sure, why not? Nor is this case involved the additional substantial connections of AMA Multimedia. The court rejected as a basis for the jurisdiction. Yeah. While ignoring all the recent authority governing personal jurisdiction in cases involving internet torts, plans rely exclusively on Keaton in support of their Washington audience argument. In Keaton, the court held that New Hampshire court could exercise personal jurisdiction over Hustler because Hustler deliberately circulated between 50 and 75,000 copies of the magazine in that state. Excuse me. Plaintiffs contend that, like the defendants in Keaton, defendants here have circulated their content to viewers of Washington and derived income through all the views of that content in Washington. However, the critical fact in Keaton was that Hustler magazine deliberately mailed tens of thousands of hard copies to the offending readers in the forum state. That's a difference, right? Yeah. Katie didn't send anything anywhere except to YouTube servers. She didn't send anything anywhere. People requested it. And that's potentially a big difference. It's a fair point. Nothing like that is alleged here. Rather, what plaintiffs allege is a mere receipt of the publication by at most a handful of Washingtonians, which resulted from the defendant's general, untargeted, and global dissemination. That is not jurisdictionally significant. It's right on the money. It's exactly where I think you should be going. Indeed, Axiom Foods, the court applied Keaton to hold the California court could not exercise personal jurisdiction over a UK defendant, despite the fact that it deliberately sent and a fitting newsletter to 10 recipients out of 343. So even though they deliberately targeted it, it was so small as to be de minimis or negligible. The court reasoned this was too small a connection between the defendants, the suit, and the forum to constitute purposeful direction. Plaintiffs argue that Keaton stands for the proposition defendants' claim may be brought in any forum where even one person... Yeah, this is exactly right. This is exactly right. This is the same damn argument I was making. I don't know if he's taking notes or whatever, but this is the exact same argument. I said this, I think, on the last live stream, and I think I probably said it on at least one live stream before that. I think I said it in my original complaint live stream. I basically said this exact argument. It's like, if you take Toddy's argument as true, it would imply personal jurisdiction everywhere, and that can't possibly be right, can it? So I've said that like every live stream. Yeah. So I don't know if he's taking notes, but this is exactly what I thought. It's like, yeah, if you take this argument as right, by their own argument, it would imply personal jurisdiction everywhere, and that can't be true. So he's making the same arguments I was making, which makes me feel smarter, which is a plus, but you know, that's right. That's the right argument. Yeah. That argument is foreclosed by Janus, Axiom Food, and AMA. All those cases involve a receipt and viewing of allegedly tortious publications without California. Indeed, they all involve purposeful targeting of Californians with those communications. And the court ruled that each personal jurisdiction could not be asserted. Several other courts have applied the same rule, that purposeful direction is not satisfied where, as here, persons within the forum allegedly received defamatory material with defendant's knowledge, but resulting only from general and untargeted internet publication. And there's even a footnote. from the California Appellate Court. So that's state level court in California, which is in the Ninth Circuit. It's persuasive authority, so fine. C. Burdick versus Superior Court from the Court of Appeals for the State of California. No personal jurisdiction with respect to claims arising from allegedly defamatory Facebook postings because the postings were targeted at a national audience and there was no evidence of expressly aiming at California rather than at the plaintiff personally. See this case from the Northern District of California, which is a trial level court, so not binding authority, but still persuasive authority. If defendant merely operates a website or other electronic medium that is accessible from but does not target the forum state, defendant may not be hauled in that court without offending the Constitution. See another case from the Central District of California, trial court, persuasive authority. The comments posted on Angie's List and Yelp are available to anyone in the United States with internet access, but there's no allegation defendants encourage California residents to access the sites. This is bang on the money. This is bang on the money. Jurisdiction is not supported by the fact defendants discuss plaintiffs' Washington connections or activities. Plaintiffs argue personal jurisdiction is supported by the fact defendants discussed Ms. Westbrook's Washington-based family and Washington connections and activities. But if personal direction is not established by plaintiff's residence in the forum state at the time of the alleged tort, certainly it is not established by discussion of the much more attenuated fact that plaintiff had connections to and unrelated activities in the forum. Indeed, defendants discuss plaintiff's family connections to and activities in a number of states: North Carolina, South Carolina, Nevada, California, Hawaii, and Washington. Plaintiffs have knowingly misrepresented their facts regarding their move from Los Angeles to Washington. This should be spicy. This might be a little bit tea-ish, but it'll be tea-ish framed in law, because we're well deep in their argument, so it's going to be tea framed in law, which is the way you're supposed to be doing this in the first place. In their complaint, plaintiffs attempt to establish personal jurisdiction solely by alleging they moved to the state of Washington in 2018. Defendants challenged this assertion in their motion to dismiss, demonstrating that plaintiffs' own social media postings show they continue to live in Los Angeles through at least the end of 2019, a full year after they claimed to have moved to Washington. In the response, plaintiffs again insist they moved back from Washington to California in late 2018 and purport to prove this by citing declarations of Toddy and James Westbrook. This assertion is demonstrably and knowingly false. Dun dun dun. Dun dun dun. In early of September 2019, James Westbrook filed a motion to vacate a default judgment in a fraud lawsuit brought against him in Los Angeles County Superior Court in a matter entitled Hawks versus Westbrook. That motion was filed by the same Los Angeles attorneys who represent plaintiffs in this case. Ooh, same attorneys too. That's not a good sign. It was premised on Mr. Westbrook's assertion the Hawks lawsuit and related papers were served on him at Hollywood, California address that he moved away from at the time of service. To establish that defense, Mr. Wook represented in his motion and sworn declaration that in 2016 he moved to a residence in Sherman Oaks, California, and that he currently resides at that residence as of the date of filing. That's, that is what one of the parties said. It's a party admission. So there you go. Of course, Mr. Westbrook cannot have continued to reside in Sherman Oaks, California, as of early September 2019 if he had moved to Washington in late 2018. Were you lying then or are you lying now? Yeah. There's some tea for you. That's real interesting that you said that you moved, because in this sworn declaration, you said exactly the opposite of that thing. Good. Yeah. The evidence overwhelmingly supports the latter conclusion. I apologize. I think I missed a sentence there. Yeah, it even says, "Are you lying now or lying then?" I was just paraphrasing that. I wasn't even reading it. I was just saying that was the question that's being asked, and now they're literally going to ask it. So how genius can I feel right now, right? I just was completely like just saying that's what they're saying, and now they're literally going to say it. So I feel special. Yeah. Either he deliberately misrepresented the facts to the Los Angeles court in September 2009, or he's deliberately misleading the facts to this court now. It's nice when I get there ahead of when they're writing it. The evidence overwhelmingly supports the latter conclusion. First, while they unequivocally assert in their response brief that they moved to Washington in late 2018, the sworn declaration testimony that purports to prove the assertion merely states, evasively, nice catch by counsel, nice catch, that they started to move to Washington. Nice catch. Bonus points. Bonus points for that one. So, they didn't say in their declaration they moved there. They said they started to move there, which is capable of so many meanings. Plus 1 bonus point for Katie's lawyer. Good catch. Good spot. Second, the Westbrook take pains to point out that they're currently Washington residents and currently have bank accounts here without stating when those events take place. Third, the Westbrook state in their brief that they paid taxes in Washington for the 2019 tax year and will pay taxes in Washington for the 2020 tax year. However, in their declarations, they assert only that they file their personal federal income taxes in the state of Washington. It is not clear what it means to file one's federal income taxes in a certain state. That's fair. I mean, you can't really file your federal income taxes in a state. Doesn't really even make sense. So, playing a little fast and loose maybe with some of our language, bonus points. Fourth, in their opening brief, defendants point to numerous social media posts from Miss Westbrook, confirming that she did not move to social media from Los Angeles until at least the earliest of late 2019. Plaintiffs respond to this by arguing the evidence is irrelevant and admissible because defendants lack personal knowledge regarding Miss Westbrook's physical location at the moments when she made that posting. That's just dumb. She can rely on that even if it's wrong. It was created at the behest of the defendant. It's a party admission. Even if it's lies, it's still a party admission. This is nonsensical. It is the content of these posts that have evidentiary value, as the parties' admissions from sources plaintiffs confirm are their own. Fifth, Mr. Westbrook declares, during the time that my wife and I owned the Sherman Oaks, California home, we no longer lived in Los Angeles, nor did we even spend a single night in the home. This appears to be another attempt to mislead. Ooh. The Westbrooks did not own the Sherman house until May of 2020. Prior to that time, they owned it with a rent to purchase. That one's a bit thin. You know, you eventually owned it, and so you count the rent to own period as owning. That's a little thin to call that a lie. I mean, it's not precise, but it's not exactly a lie. It's like, yeah, you technically didn't own it, but you lived there with rent to own, and you owned it later. So, yeah, I lived there, I owned it the whole time. I mean, you know, you gotta give you a little bit of slack. You know, that's a little bit thin to say that's a lie. Yeah, that's a personal opinion, though. As such, even if they were true that they did not live in Los Angeles or stay in their Sherman Oaks house during the time they owned it, that certainly does not support their contention they moved to Washington in 2018. Finally, the fact that Westbrook signed a lease late in 2018 for a condominium in Bellevue, which they've used as a corporate address for several entities, does not overcome the sworn testimony regarding California residency as late as 2019. Fair. And the fact that Miss Westbrook posted a photograph of herself in her condominium as February 2019 is not evidence it was residence at the time. I think I pointed that out as well. I think I made a point of pointing that out as well. Yeah, just because you took a photo. Yeah, I did. In fact, I remember specifically pointing that out in my prior live stream. I remember saying it because I made a point of saying, well, just because the photograph was taken there doesn't mean they lived there. What I said on stream at the time was maybe she was on an apartment tour and she took it during a tour, right? So I made a point of this like 3 live streams ago. Yeah, Yeah, no, that's fine. We can crib me. That's fine. That's fine. Yeah. Defendant should grant the remainder of defendant's motion to dismiss if it does not dismiss the entirety for lack of personal jurisdiction. The Ninth Circuit and district courts have held Doe defendants defeat diversity, at least where it's filed in district court. I can't speak to that one way or another. I'm not educated enough on the law in the Ninth Circuit on that specific issue, so I'm going to have to take a pass on that one. Plaintiffs fail to plead intentional infliction of emotional distress. Plaintiffs cite a Washington case for proposition that Washington courts focus more on outrageousness of conduct rather than specific symptoms of emotional distress. But the case they says nothing of the sort. I am not a fan of this because you don't say what the case says. I have no problem with you saying they're misreading the case, but you can't just say they're misreading the case. You have to say, here's the proper reading of the case. So, you needed another sentence or two here, man. So maybe they are misreading the case. What do you think the proper reading is? Would you like to provide a reading? Apparently not right now. I guess. All right. They're citing a previous docket entry, but I would put it here explicitly. So even if because that's asking the court to do too much to go look it up in a prior filing. You should mention it here. It's important enough. Plaintiffs failed to plead negligent infliction of emotional distress. Defendants pointed out in their motion that plaintiffs failed to plead they suffered a mentally diagnosable mental or emotional disorder, such as neurosis, psychosis, chronic depression, phobia, post-traumatic stress, or any other disabling condition. In response, plaintiffs rely solely to a citation of a dissenting opinion of Snyder. Was that a dissenting opinion? Was that a dissenting opinion? Did I make a mistake? I might have made a mistake because I read it and I failed to notice it was a dissenting opinion. So did I make a mistake? Hold on. I want to go check this out because I might have made a mistake by failing to notice it was a dissent. Hold on. Talk amongst yourselves. Snyder versus Medical Services Corp. Let's see. Snyder claim negligent infliction. Blah, 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 blah. Must be allowed to making decisions. Negligent claims can establish duty, approximate cause, foreseeability of harm. PTSD. Keep talking amongst yourselves while I try to figure out whether or not I made a mistake last time. I don't like making mistakes. No. I didn't. Wait. Yes, I did. Damn it. I made a mistake. I didn't notice it came from the dissent. They're right. Yeah. Katie's lawyer has showed me up. I didn't notice when I looked this up before that it came from the dissent. I missed it. I made a mistake. Bummer. Katie's lawyer showed me up. I guess it's another point. Yeah, I missed it, made a mistake, and I failed to notice it came from the dissent when I read that before on stream previously. Lame. You got one on me, man. Defendant pointed out in their motion to plead, so it comes from a dissent, and they failed to mention that, and that's a big no-no. That's a big no-no. You're not supposed to do that. Oh, there's 1,158 of you watching right now. Oh, 1,200 of you watching. Thank you for the 1,200 of you watching. Might I ask, if you've not done so already, for the 1,200 of you, might I be so bold as to ask you to please subscribe if you're enjoying this content, including the parts where I go silent for a while I quickly read to figure out if I made a mistake on a prior live stream when I read something and failed to notice something and made a mistake on something. It's like, I made a mistake in this proposition here. So if you enjoy that kind of thing, if you could hit the subscribe button to help the legal channel grow, I'd appreciate it. That'd be great. Thank you for the 1,200 of you who are here. You're all awesome. Plaintiffs failed to plead the public interest element of a CPA claim. Defendants argue the complaint fails to adequately allege defendants' alleged defamatory publications are injurious to the public. I did notice Salty put me on his Twitter. That was very, very cool when he did that. That was very, very cool. I did appreciate that. Plaintiffs responded defendant have a YouTube channel that covers celebrity gossip. That does nothing to cure the failure to allege facts to support a plausible inference. This is anything more than a private dispute. If the mere speculation that defendant might direct wrongdoing at other persons was sufficient to state a claim, every alleged tort would be a plausible violation. Maybe. I think it might prove too much. I like this argument. I like this argument, but I feel like, I don't know, something about the wording of it is wrong, or maybe it just needs to be flushed out more. I think it's too conclusory. I like the idea that they're going for. I just don't like the way that this is phrased. It's the right idea, but the execution leaves a little bit to be desired. It needs to be flushed out a little bit more. It needs to be emphasized a little bit more. It's a little conclusory the way it's phrased. Maybe they're trying to hit a page limit or a word limit or something, and that's why it's written this way. But it's a little bit confusing on its own terms. I think there's an idea here to be had. It just needs to be reworked a little bit, but okay. Your mom from Scotland enjoys me? Well, awesome. Fantastic. Thank you. Defendants argue plaintiff may not bring their claim in federal court under the criminal procedure statute of whatever. Plaintiffs cite an order in which Judge Martinez allowed such a claim to be brought. Defendants simply believe Ferguson was wrongly decided. Hey, there you go. I mean, it's only persuasive authority because we're at the Court of Appeals. So they cite a case from the district court in the Ninth Circuit, and they say, yeah, they just got it wrong. They got the law wrong. So, hey, that's, you can do that. Yep, the court, that court in that other case screwed it up. The guy came up with the wrong conclusion. Okay. You read it correctly. I just think they screwed up the law. Yeah, that you're talking to the people who could fix that problem. The Court of Appeals could fix that problem. Further, plaintiffs fail to justify their continued and telling failure to fulfill the explicit statutory requirement. The claim shall be accompanied by an affidavit made under oath stating specific facts and circumstances. There were a few super chats which I have not acknowledged. I should go back and acknowledge them all. So I'll just go back and do all the super chats since the beginning. $5 from Akita Law. Can't watch live, but I know you'll have a thoughtful analysis. Well, thank you, Nick. I appreciate your super chat. That's very thoughtful. Remember to check out Nick Rakita. His channel is growing as well, and it's super awesome. We had a new member today from Heather Bain, a new member from Book Nerd S. Awesome. $1.99 from Nadia. Love the new lens. I am loving the new lens too, man. It was really working out very well. I'm very, very pleased by that. Barry Readable became a new member. Thank you. $4.99 from Jeep Runaway Girl, 713. How's it going? It's all right. Blonde Asian became a new member. $4.20 from Rick. Don't look, but your viewer count is showing. Hey, 1,200 viewers, ma'am. Awesome. Please subscribe. I am not beyond begging. Please subscribe. Yeah. Wolfgang Deo, $5. Lockdowns caused this. I'm political refugee after the most American day ever, Declaration of Independence. 99 cents from Boomhauer 100, who gave me a pile of poo. $2 from Urel Gray. You rock, Kurt. Glad I made it to you live. I'm glad you made it live, Urel. Myra M. So I went to mylife.com. It says, if I see someone, I know I will not publicize their information or spread gossip. Well, I guess she shouldn't breach a contract, but there's a whole other set of problems. $5 from Bixby Lou. If jurisdiction is found for defendant, would that nullify other orders, such as the defendant not to delete your crap? No. No, it would not delete. It would not affect that order either way. So, no. And Skynet Podcast became a new member. Well, thank you, Skynet. Please spare me in the apocalypse. I appreciate that. Turn around every now and then. Get a little bit lonely, never come around. Turn around, bright eyes. Every now and then I fall apart. Okay, let's cancel the singing before I lose even more subscribers. Let's see. Plans strangely insist they're not required to file an affidavit because of a provision that allows for an ex parte application to be granted upon the filing of an affidavit. Finally, plans cite no authority for the proposition that internet publications about a person without more constitutes knowing and willful course of conduct directed at the person. That's right. Just because it's about you doesn't mean it's directed at you. We can have conversations about you without talking to you. $5 says, well, over half of you have not liked the stream. I might be asking a lot, but a thumbs up for Bright Eyes, hey, that's what I'm saying. Sing, give me all the rest of it. Defendant's conduct involves filing multiple meritless lawsuits against plaintiffs. The filing of abusive, frivolous lawsuits may be contracted directed at a plaintiff. Okay, yeah. Posing and fledged inflammatory stories about a plaintiff without more is not. Dated this 6th day by Michael Brown. Well, Michael Brown, you have earned our renewed respect. You have come up with a very solid, excellent argument. Good job. Good work. Someone asked in chat, what defines talking at versus about someone? Well, I mean, typically when you're gossiping about that person, but not to that person. Because why would you gossip about that person to that person? So gossip is a pretty good example of a situation when you're talking about a person, but not to the person. Very specifically not to the person usually. So yeah, I was talking about you, but not to you. Because I was gossiping about you to like literally everyone else. Yeah. Hero says, I see you have 20,000 subs now. Phoenix Right Time. We might have to give it another go at some point. $4.99 from Andy's mom, Sammy. We came in part for the singing and the headbanging. The honest and unbiased law content is just a bonus. Well, I'm glad going fell. Have you seen the literal interpretation of video of Total Eclipse of the Heart? I don't believe I have, but some of those are hilarious. I also like the bad lip reading videos. Those are fun. Bad lip reading? Yeah. Is it my birthday yet? It is not my birthday yet. My birthday is a week on Wednesday next. So it's 6 days away, on the 13th. What's the lawsuit about? Tea. Lawsuit's about tea. You know, it's about, you know, the Lipton Tea Company has gotten into a contractual dispute regarding the availability of tea. It has a lot to do with COVID and the fact that people are just not able to get out of their homes as much. And so, you know, the Lipton Company had a put order for some tea, that they had a contractual relationship that they'll guarantee a supply of tea. And because some people are not showing up to work as much, people aren't able to grow as much tea as they were before the COVID. So Lipton is suing over the breach of contract for the tea violation. That's what's going on. $2.99 from Jan Hack. Don't see the button to become a member. Subscribed. Yeah, I mean times are tough out there for everybody, and the shortage on the commodities market is real. You know. People like their Lipton. What can you say, man? All right, so let's read some more. What happened to my green screen? I couldn't find a background I liked. I'm very, very picky, and I haven't found one I like. Please pull up Without a Crystal Ball's Twitter. Really? Why am I doing this? Why am I pulling up her Twitter? Is she tweeting about me? Is she saying how I think her lawyer did a really good job? Is that what's going on? Is she saying how she's been vindicated and her lawyer's really a genius or something? Does she have a Twitter? I can't even find her Twitter. Oh, Without a Crystal Ball official. All right. So what's she tweeting about? I don't buy subs. Okay, that's nice. Email communications go away. Just like I'm being watched, so are you. We know everything. She's tweeting. She's doing some tweets. Not necessarily advisable. She's doing some tweets and some Twitters. That is the thing that's happening. She is, in fact, defending herself. Probably not advisedly, but that's what she's doing. How would I rule in the motion to dismiss? Well, let me get to the end of it, and I'll give you a revised opinion. But we still have some supporting documents, so I'll read some more before I give a revised opinion. That sounds fair, right? Let's read some more things before I come up with a new opinion. So we have a declaration, so a supplemental declaration. So Katie Paulson has some revised comments she'd like to share. She's over the age of 18. I understand the plaintiff's lawsuit against me is based upon videos I made which discuss facts regarding Toddy and James' life before they became famous. The information includes facts from public records regarding James' life in North Carolina. He's a North Carolina, South Carolina boy, so he's kind of from my neck of the woods. I like him even more. North Carolina, South Carolina, Nevada, California, Hawaii. It also includes facts from public records regarding Toddy's life in Washington before she moved to Los Angeles. I understand plaintiffs now contend I use Washington sources to obtain information relating to Toddy. This is not true. In the context of media and reporting, I understand the word sources to refer to persons who provide information relevant to the story. To my knowledge, I had no contact whatsoever with any Washingtonian resident in connection with developing or posting these stories. That's probably true. Nor did I travel to Washington or access any Washington records database. That seems to be true, as best as we understand right now. Instead, while in my Minnesota home, I obtained electronic images of relevant historical Washington records regarding James and Ty from two websites, Ancestry and My Life. I was not specifically looking for Washington records or records from any particular state. Rather, I wanted to find whatever I could, regardless of where it came from. That seems totally plausible. That seems very plausible. She was looking for any information from anywhere. That seems very, very plausible. Rather, I wanted to, It's my understanding that both these websites are accessible globally, include information records from all over the United States. In using these websites, I viewed electronic copies of relevant records from numerous states, including North Carolina, South Carolina, Nevada, California, Hawaii, and Washington. The document images were on a website itself. To my knowledge, they don't link to local websites in various states where the originals and records are stored. Okay, we're going to completely deviate from this entire lawsuit for a little bit of personal story time because it's my channel and I can. A year ago, I decided to get a little bit into Ancestry and use Ancestry.com. So first of all, Ancestry.com has perhaps a disturbing amount of records because of how many records they have. But it was very, very interesting. And I learned quite a lot about my family I did not know before. So I learned, doing the records and finding, it was really interesting. Finding like original immigration records, original citizenship papers from some of my family becoming citizens and their original visas, finding records of the boats they were on, all kinds of shit. It was really, really cool. And I learned that I had one branch of my family that lived in the United States since the Revolution, which I didn't know. I was under the impression that my entire extended family came to the United States, 2 generations back. No, that would be my great grandparents, 3 generations back. So I was under the impression that all my family came back 3 generations back. But that isn't true, actually, it turns out. It turns out that I have one of my family line actually goes as far back as the Revolution, and I couldn't get back beyond that for at least one of the records. It was really cool. And it also turned out I had an ancestor in the Civil War, and I think 2 in the Revolutionary War, all fighting for the Union. And one of my relatives who fought for what would be the Union, or what would be America, originally was British. He was a British soldier. He defected. Yeah, he switched sides in the middle of the war. So he was a colonel. He was a colonel in the British Army, and then he was a colonel in the UK, in the American Army. Yeah, that's the thing that happened. He defected. He kept his rank, though. Good for him. So I guess it worked out for him. But it was really, really cool. I really liked it, and I really liked finding ancestry records and finding my family tree. And I was able to get back pretty far on my mother's side. For English and Scottish, I was able to get back pretty far on some of those records. Really, really cool. So I don't know if any of you guys are into the ancestry stuff, but just to let you know, it's really interesting. Finding like old court records, old baptismal records. Ancestry.com has the weirdest shit. They've got baptismal records from Rando Church in Germany from the 14th century for some bullshit reason that I'm able to look up. How is this a thing? I don't know, but they've got records from everywhere. It's really, really cool. Yeah. So just personal story time. Ancestry.com is fun. You get to learn things like you had relatives in the Revolutionary and Civil War. Yeah. Document images were on the website itself. To the knowledge, they don't link to local websites in various states where the originals of records are stored. It's a thing because they're owned by the Mormon Church. That makes a lot of sense. Yeah, so they actively seek out the records. That makes sense. Yeah. In response to plaintiff's statement that YouTube channel operators can get data on where the subscribers live, I've researched the matter and discovered that during the period relevant to this lawsuit, only 0.07% of my subscribers live in Washington. Okay. I have never directed by content at Washington State. That's a typo. That's why I had to read it 3 times. It's a typo. I never directed my content at Washington State or done anything to develop or appeal to a Washington audience. My content is targeted at a global audience. In fact, 40% of my viewers are from outside the United States. Yeah. Prior to this lawsuit being filed, I've been in contact over social media with Lori Ann Barnhart on a few occasions. I did not know that she was a resident of Washington. I am unaware of the state of residence of most of my subscribers and viewers because that information is not important to me or my business. When I referred to Miss Barnhart as my best friend, I was not meant literally or even seriously, which I completely and totally believe. Miss Barnhart may be shattered to learn this information, however, because Miss Barnhart seems a little ride or die. Miss Barnhart, I hate to break it to you since you're a little ride or die, but Katie Joy just disowned you. So there's that. That's the thing that happened. It was a lighthearted comment on the fact that she's been a critic of mine and turned into a supporter. I meant as hyperbole. I believe the context makes it obvious to any reasonable person. Miss Barnhart is learning some very uncomfortable truths right now over here at Uncivil Law. I'm sorry to break it to you. I didn't want to be the person to break it to you, but apparently I'm the one that has to break your heart. I'm sorry. Katie Joy is not your bestie. It's very sad. I'm sorry. It's in a sworn affidavit, man. It's over. I had very limited interaction with Miss Barnhart. Do not know her well and do not consider her to be a friend at all, let alone my best friend. Whoa, the burn. Holy God. Wow, we went for the jugular. I guess that's one way to do it. It's a mercy kill. I do not consider her to be a friend at all, let alone my best friend. Rip her throat right out, man. Bleed out on the floor. Miss Barnhart. Oh, my God. Oh, it's brutal. It's so brutal. Oh, my God. Wow. After plaintiffs filed a declaration from Kim Fulmer exposing irrelevant personal details about Lori Ann Barnhart, Ms. Barnhart sent me several messages during a live stream I held on December the 29th, 2020. Because she was not a subscriber to my channel, she paid a small amount of money to see these messages, a total of approximately $25. I understand the plaintiffs argue I knew that viewers on my channel were Washington residents, and then I identified a total of 3 very short chat messages sent to me on video broadcasts from people who identified they're from Washington or Seattle. Plaintiffs do not even suggest these videos are in any way related to this lawsuit. I received hundreds of comments and chat messages during each one of my videos. I do not track where they are from, nor can I recall wherein I acknowledge Washington. One of the thoughts. I said this too. I basically wrote point 8 of this affidavit. This I said on a prior live stream too. Now I got Katie Joy ripping me off for her own affidavits. I should sue for copyright infringement. That'd be good. Yeah, because when I did say it on live stream, it did become recorded in a fixed medium, which means I have a copyright interest in it, right? So yeah, I said this too. It's like, yeah, I can't possibly remember this one thing I said one time. This is me. Just rip point 8 right out of my live streams, man. I got the attorney cribbing me. I got Katie cribbing me. That's all right. I'm here to share, I guess, and then we declare that to be true, and that's the end of that. All right, great. Let's left one more. Yeah, send her a bill. That'd be good. Send her a bill. I'm not going to sue her, guys. I'm not going to sue her. I'm not serious. It's fine. I may, however, order some Halo beauty products because I think it might be hilarious. All right, so we have one more thing, which is 34 pages long. 44 pages long. I'm not sure exactly what the 44 pages are, but we're going to find out together. Defendant makes this request for supplemental notice for judicial notice, true and correct copy of the whatever. The court may take notice of stuff, blah, blah, blah. That's great. Okay, Exhibit A. So what do we got? Okay, so now we're submitting a copy of the lawsuit. The defendant, okay, so this is some other stuff we want them to take judicial notice of. Defendant James Westbrook's motion to vacate. So this is from the other lawsuit we covered. We couldn't actually find this document before. So this is the motion to vacate that one. This is the one that James Westbrook was found liable for. What was it exactly? I forget. It's been a little bit now. But he was found liable for something. Fraud, I think, maybe? In a civil context, civil fraud or something. And he defaulted into it. We covered that in the live stream with that when he couldn't find the motion to set it aside for some reason. So like fraud and something else. Whatever. But yeah, there was a judgment put against him for that initially, and then he moved to set it aside because it was a default judgment. He never showed up, and he liked it to be set aside. Yeah. So there's a motion default on the basis that I never got service process, which is a perfectly reasonable basis to do it. Okay, fine. And this is signed by Saltz, same lawyer. Interesting. I mean, it's not that interesting, just notable, I guess. I mean, it's not surprising that they'd have the same lawyer for two things. So now we're attaching this Memorandum of Authority, which I'm probably not going to read this because I don't care. Is this verified? No. All right, so we're going to move to set aside the judgment. I never got process. Here's a whole bunch of things that happened in sort of the timing of the case. Here's the relevant law. The motion is timely. They didn't serve me with process. It's abuse of discretion, absent clear. If I didn't get it, if it's not my fault, I can't be held responsible for it. Therefore, you should release me of this. Okay, that all makes sense. Hey, Nate the Lawyer is here. Nate the Lawyer is here for $4.99. Nate the Lawyer is awesome. Everyone should go to Nate the Lawyer's channel. He and I stream on Wednesdays. We do legal analysis. We did legal analysis yesterday for 4 hours during the middle of the Capitol being, assaulted and crap. And he's awesome. Nate the Lawyer, you should go to his channel and subscribe as well. He's great. He's the one who recommended this case to me. So this is all his fault. Yeah. You're awesome, Nate. Love you. Hope your day's going well. All right, so we moved to this. Okay, so yeah, I just summarized 7 pages of legal filings. We never got service. It wasn't our fault. The lawsuit, the default should be thrown out. Now, here's the interesting one. Okay, so now we have a declaration from Saltz. In the prior lawsuits, dealing with the defamation or whatever he was charged with, I can't remember. So here's a whole bunch of things that happened. There's proof of service. It was attached to this place. Blah, blah, blah. There was not, the process server didn't give us service. Blah, blah, blah. Here's a whole bunch of things that happened. Therefore, it's not our fault. Okay, I buy all that. Now, here's the one from James Westbrook. This is the one that we really are coming into this for. This is the one where James said, well, actually, I was living in California the entire time. Dun, dun, dun. This is the one we're here for. His entire thing is here merely for like one sentence. We have 44 pages of document for one sentence. Sometimes that happens in law, but we'll press on anyway. Blah, 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 blah. All right, so here we have some sentences from James Westbrook. So he says, I wasn't evading service. Okay, great. I had no connection to whatever address. Okay, he says, I had no connection to this address in Los Angeles in 2016. Rather, I lived in this address in Los Angeles from June 2001 to September 2014, at which time I moved to Studio City, California, where I lived until February 2016. In October of 2016, I was living in Sherman Oaks, where I currently still reside. Dun, 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 where I currently still reside. I lived in California the whole time. I totally lived in California. Yeah. And this was signed in August the 22nd of 2019. So James says, as of August the 22nd, 2019, I lived in California. I didn't live in Washington. Dun, dun, dun. And what's even a little bit more interesting about it is that Saltz, of course, presumably would know this because he was the lawyer in that case as well. So someone's got a little bit of explaining to do somewhere about that little disparity. So do we care about anything else other than literally paragraph 11? Do we care about literally anything else in this 44-page document? Let's find out. Probably not. There's an Exhibit B. This is dealing with the business. Oh, is this the business partner? Swanson versus Halo? Declaration of James. GGU Christine gave me $5. Thanks, man. Yeah. So Clark Swanson. Yeah. By the way, I'm definitely going to get into this case. I'm definitely going to get into this Swanson versus Halo Beauty thing. I'm trying to find time, but I'm absolutely going to get into this because I'm here for your tea-related needs. I will do all the tea forever if it helps with the subscribers. I want to give you the content that you want to subscribe for. Deep concepts at work, right? So if you guys like tea, you get some tea. All right, so we got the special appearance regarding this Swanson thing. What are we reading here? This form isn't convenient. Fine. The real party. Okay, so now we have, yeah. So now we have some more. The real parties do not reside in California. Okay. Defendants are residents of Washington State in 8. Oh, is this the same thing or is this a different thing? No, this is a different thing for sure. We get some tables of authority. We want to argue that Clark Swanson is Nevada and Swain is Swanson's complaint falsely asserts that they're domiciled in California. As explained, this is incorrect. So there continues to be arguments about where Toddy and James live or lived. There appears to be a dispute on this issue, including in James's own sworn affidavits. So there's a dispute over this issue. The plans are Nevada residents. That's fine. Swanson complaint alleges Westbrook reside in California. Toddy Westbrook resides in a address which I just put on screen, which I don't know what I'm going to do with that. I should have probably redacted that in advance. And some other stuff. And yeah, great. I don't know how to deal with public addresses in court documents. I mean, it's public record, but still not ideal. Thank you for all the subscribers, by the way. That Streamlabs finally catches up. Swanson's and Westbrooks decided to move from Halo Beauty to California for Nevada for tax purposes. They underwent some reorganization. They want to create Halo Beauty. Blah, blah, blah. 15 causes of action. Westbrook's orally promised to make Halo Mr. Westbrook's exclusive channel for all things beauty. Breach of duty, breach of fiduciary responsibility, legal standards for the relationship, where it should be heard. Why am I reading this at this point? I guess I'm reading it for the bombshell proposition that they are inconsistent about where they live. I think that's what I'm reading it for. There's an inconsistency about where Salts and James say that they live or lived. That's what I'm understanding. Now, I'm not saying there is an inconsistency. That's the argument, and it seems to have some merit to it. But I'm not going to cast aspersions, especially on Salts, without hearing his response first, because I don't want to throw another lawyer under the bus, because I think it's very, very mean. But there does seem to be something that needs a little bit of explanation. Maybe there is some explanation to be had. California doesn't have an interest in this. Nevada's a proper forum. So I think we brought in that entire document for the proposition that they've been inconsistent about where they lived at various times. I think that's the reason that document exists. Can't you reside in more than one state? Yes. And domicile that really matters? Yes. Those are true things, yes. She's attacking Emily and Salts. Oh, you shouldn't attack Emily, but Emily's a big girl. I don't know. Is she attacking me? I mean, I don't know. Is she attacking me? At this point, I'm saying really, really good things about her lawyer. Like her lawyer's doing a really good job and raising some really excellent points. So does Katie want to say nice things about me, or does she want to say mean things about me? It does depend on what's going on at any given time. I don't know. What can you do? Declaration of James Westbrook in motion for the motion to dismiss. His address is wherever. He has a driver's license from January 2nd, 2019. He has personal bank accounts there. He created a company. So I think this is about, he had a driver's license in Washington on January the 2nd of 2019. That's really interesting. Hold on. I'm going to scroll up many pages here. So he resided in Sherman Oaks until August of 2019. But he had a driver's license in Washington in January of 2019. That's really confusing. So there's some things here that are inconsistent in terms of where people live, which matters for diversity jurisdiction if no other reason. Trying to figure out where they live is kind of important. I don't think it matters here, but it's still kind of notable. So something is wrong with this picture. Exhibit C. This Declaration of James, who says this was signed in the 15th of December of 2020. That's like just happened. Blah, 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 blah. There just seems to be inconsistencies about where they're living, if I'm understanding correctly. We got a declaration of Tatiana Westbrook for the form of nonconvenience. I made the decision to become a resident of state of Washington in December 2018 and signed a long-term lease. So there's just inconsistencies about where they live. Is basically why we're bringing in this stuff for the bombshell proposition. There's inconsistencies about where they live between the different documents. So, yeah. So, first of all, excellent job on this. Excellent job on this paper. This was the answer that we were looking for, and this provides some really good arguments. So it's a little bit hard for now in terms of where do I think that puts us. I mean, I think just in the interest of being honest, and this is not different than anything I've said before, so it's not like I'm saying anything new, but personal jurisdiction is something I'm a little bit weaker on in terms of legal, because it's not something I have to deal with in my job. It never comes up because I don't have this problem. I have federal question jurisdiction. It never comes up. Patent law, federal question jurisdiction. Personal jurisdiction never comes up. So I never have to deal with it. Anyways, so I don't know the finer points of this because it's not something I have to deal with or think about ever. But that being said, I think there's some really solid arguments. This is the argument I would make if I were Katie's lawyer. This is the right argument. I didn't do anything in particular to target Washington. I put things out generally. It's everywhere. I don't have a particularly high membership base. Also, my ride or die fan is living under a delusion where they think I care about them. Harsh, but there you go. My ride or die fan can apparently die because I don't care about them. Rough. I didn't do anything in particular to target them. And I really like this argument about this brunt of the impact being under. So the most legally impressive thing here for me was this argument on page 3, where they argued that this language, we take this opportunity to clarify our law and state that the brunt of the harm need not be suffered in the forum state. And where this guy is taking this language, what's his name? I keep referring to him as this guy. I keep forgetting his name, and that feels disrespectful. What's his name? Michael Brown. Mr. Brown. So when Mr. Brown wrote this argument about, he said, well, this court case says this about the brunt of harm need not be suffered, but what they were really trying to say was only for the third element. And if you go look at these other cases, you need that brunt argument. So he's trying to minimize the impact. I really like this argument a lot. This is a very clever, creative argument. And this is a sophisticated argument. And I think, no disrespect to anything else he said, because the rest is solid. But I think this argument from the beginning of page 3. Yeah, so from the beginning of page 3 through the end of page 4. So for 2 pages, page 3 and page 4, that's the best argument. He wrote a very creative argument. It's brilliant. And it makes a very solid argument that makes a lot of sense and is very much in track with what I'm thinking. And so what do I think about where this is going to go now? I'm not 100% sure, but I don't know. I suppose it depends a lot on what this court thinks in terms of the case law and what they think. Now, courts are generally hesitant to give up jurisdiction. So I think you'd have to predict still that Toddy is going to be able to sue here. But we learned a very critical fact that we didn't know before. And I have no reason to doubt it's true. That she never actually accessed any records from him in Washington. We assumed, and there was no reason not to assume it. It was a reasonable assumption. But it just is not correct. It appears that she didn't get the records from Washington. It appears that she didn't go into Washington databases. She got them from third-party companies. She didn't do anything to target Washington in her videos. I think that's fair. She put her videos out generally. She didn't do anything to to advertise them specifically to Washington or otherwise target them to Washington. She just put it out for general consumption. She didn't really care where people watched them. I think that's true. Why would she care? There's no particular reason for her to care where people watch them. She just wanted people to watch them. So, and I also really liked the argument because it was my argument, damn it. I came up with it. I really liked my own, so I really liked my own argument where I'm like, yeah, if Toddy is right, it implies personal jurisdiction everywhere, and that can't be true. So this is a really, really solid argument. So at this point, I'd have to tentatively, I'm having a tough time scoring it because I'm acting in a space. What if I just say it's too close to call? Is that a cheat? It's a bit of a cheat. I guess I'd say 60% for Toddy to win. It's about the best answer I can give. I can really see it being, it's a bit of a toss-up. I would have said 90% before, and now I'm going to say 60%. 60% for Toddy to win and be able to keep this lawsuit going here. I think Katie's lawyer, Michael Brown, made some really solid legal arguments, and he should be, and Katie should be pleased. Her lawyer did a very solid job. I can't see anything particularly wrong with it. I mean, I did quibble over a word choice or two. There were a few things that I would have written maybe a little bit differently, but on the whole, it's a perfectly solid, cogent, professional legal argument. It's great work. Where was this lawyer in the motion to dismiss continues to be my ever-pressing question, but that's another problem for another day. So, yeah. Holly Grace says she's had I like this comment from Holly Grace in my chat. Holly Grace in my chat says, I've had about enough of armchair lawyers. What? Why are you here then? I mean, no disrespect, Holly, but if you've had about enough of armchair lawyers, what are you doing here? Okay, I'm all right. It's all very weird. Let me just respond to a few questions in Q&A. I'll just scroll down and see what's going on here. She could have moved without James and stayed behind, do paperwork and stuff. That's fair. They might have moved separately. That's perfectly reasonable. That's a reasonable possibility too. They might have lived in different places, although the depositions don't make that particularly clear. Emily will chew up KJ and spit her out. Probably. Yeah, Toddy could have moved before James. They could have moved independently. That's fair. That's definitely a possibility. When is the date the courts will decide whether to dismiss this case or not? Relatively soon is the best answer I can give you. Probably within a month if I had to guess. Of course he did a good job. He took it by shtick. Yeah, maybe. I mean, it's exactly the right argument. It's exactly where I think he needs to be. Salts did tweet about me. That was awesome, yes. Thank you, Yarn Queen, for becoming a new member. Oh, and I did miss a super chat, I think from Nuvi, $5. You think after the Sargon Akil obviously people will learn not to take litigation on Twitter. That is a good thing, but people do not learn. And all the criminals don't learn not to. This is reflecting on my earlier stream. But it's like, how are the Capitol Police going to find the people who were involved in the rioting? How are they going to find those people? And the answer is they're going to find them because those people are going to post videos and photos of themselves on their own Facebook pages. Because people are idiots. Yeah. Maybe don't post the video that you took yourself of you breaking the law and post it on your own Facebook page. Might be a good idea, but You know, what do I know? Yeah, you can live in two different places. You can have more than one residence, so you'd be thinking about domicile more than residency, but whatever. Yeah. You're fighting Corona, Bixby? I hope you get better. If you have 5 properties in 5 states, which state do you reside in? Well, you might reside in all 5. Well, usually the rule is where you spend at least half your time. If you don't spend half your time at least anywhere, then maybe you don't have any actual, maybe all your residents are equally resident. But you can only have one domicile. And the domicile, it's complicated, but yeah, legal domicile, you can only have one, and it's once you establish it, it remains that until you change it, and you have to do it very expressly. But we don't have to argue about that. That's really geeky civil procedure stuff. That's too much for this time of day. Get my commission. Wait till contempt charges come at her. There might be contempt charges. I know Emily thinks that they're very, very likely. I'm a little less convinced, but we'll see how it goes. Toddy and James own Halo together. Uh, hold on. Clark Swanson owns it as well, right? So he's a business partner as well. So it's Toddy and James and Clark Swanson. I think. Something like that. She's still tweeting about this. I wouldn't necessarily recommend it. I wouldn't necessarily recommend tweeting about this case. Real in Fiction says, my first time catching an Uncivil Law going over Toddy and KJ. I adore Emily Baker. She's very nice. She's funny, maybe too nice. Uncivil Live is the best. Love is sarcasm. I'm glad you like it. 1,250 people live. I will once again remind you to please subscribe. Please subscribe. Subscribe. I'd appreciate it. Thank you. How do you get a birth certificate? Apparently in Washington State, although the law changed as of January 1st, apparently anyone could get anyone's birth certificate. So just ask the government and they'll give it to you, apparently. At least as of before January the 1st. Can it be confirmed she got doxxed from there? I mean, she's swearing to it, so that's something. For the purposes of the motion to dismiss, though, you would just assume that everything the plaintiff says is true. So it doesn't really matter for the immediate purposes, because you'd assume that anything the plaintiff says is true, because that's what you do in a motion to dismiss. You assume everything the plaintiff said is true. The whole point of the motion to dismiss is if everything they say is true still doesn't win, then what's the point of going forward? So, do your Halo ads for our special guest in chat? Yeah, no, Halo Beauty, man. Halo Beauty is what I rely on for my life. As a YouTube streamer, I am cognizant of my appearance and my overall demeanor, because I know how important it is to really be able to effectively communicate. And the products that I rely on the most to help me with that is Halo Beauty. Halo Beauty for the YouTube streamer in your life. We need Jeopardy music when he's looking something up. Yeah, probably do. What's up from Texas? Yep, I'm right here in Texas myself. Gotta love Texas. How many drinks have I had? Some. Some drinks. It's tasty, though. Marilyn says, it's true you live in Washington. That's funny. What made me decide to start YouTube? Well, what made me decide to start YouTube was Leonard French. Lawful Masses with Leonard French. He's another YouTube lawyer. And he was the first one I ever found. And I don't remember, I mean, how did I discover him initially? Who can say? You know, that's going back a lot of years. Did he pop up in my feed because of related content? Did I see a Twitter post? Did I see a Facebook? I mean, who can say? But Lawful Masses with Leonard French. Leonard French was doing these videos. He's doing YouTube videos. And I joined his Discord. And I hung out with him a while. And then I reached out to him. I was like, you know, I'm a lawyer too. Maybe we could do a video together sometime. And then eventually that happened. And then we did a couple videos together. I went up to his house a couple times in Pennsylvania. He came to my house a couple times in Virginia when I lived in Virginia. And we were pretty good friends. And he's since moved to Luxembourg, and I've moved to Texas, so we don't get to see each other as much. But you know, we're still friendly. And anyways, so he was doing this, and I did joint streams with him, and I did some content for him. And his fifth or sixth most popular video of all time is a video from me with the Myrtle Beach raid. So like one of his most popular videos of all time is a video I produced, which I'm, you know, more than happy to give to him. It was fine. So anyways, I did that for a while, and then I said, you know what? What if I just did this myself? What if I created my own channel? And then I did. And the rest is becoming history, as we say. So that is how that all came to be. And the reason I do it is because I love it. I love law. I love talking about law. I love the subject so much. I want to talk a lot about law all the time. It's the greatest thing ever. And if you don't love law, you're wrong. Is it warm in Texas? Yes, I like it here. I do feel bouncy and confidence. Bouncy and confidence, yes. I feel all those things. It was very podcasty and very good. Thank you. Momentum builder to the god of speculation. Nice. Uncivil, I just wanted to let you know I greatly enjoy your channel. Thank you. I think I'm becoming better with every passing day. I continue to invest in this channel. I buy the new lens. I buy the green screen, which I'm not using right now because I can't find a background I like, because I take this pretty seriously, right? I've got people helping me with editing. I'm helping people get me stories. I'm continuing to invest in this channel and make it the best channel it can be. And I've hoped to become only better. What's the next legal step from here? The decision from the court for the motion to dismiss, presumably, will be the next thing. Katie's having a sale on membership. Halo doesn't do sponsorships or PR, but Toddy will have to change it just for you. Maybe. So can this whole thing get dismissed based on jurisdiction? Yes. If personal jurisdiction fails, the whole thing goes away. And it will have to be refiled in Minnesota. So that's the big consequence. So if personal jurisdiction fails, everything fails. And it'll have to be refiled in Minnesota. So we'll see. Elena says she knows what my birthday presents will be. Okay, I look forward to finding out. Should you move to Texas? Depends. Are you from California? Then no. How's much? What's my poison tonight? Oh yeah, I'm drinking this Texas pecan brown sugar bourbon. And it's fucking tasty as hell. It's great. It's awesome. I am in fact single. That is true. It's snowing in Tennessee. That's pretty cool. What part of Texas do I live in? I live in downtown Austin. I am in fact a patent lawyer. That is true. Yes. I am a patent lawyer. When I move states, you have to take the bar again. I haven't taken the bar again because I'm a patent lawyer. I'm working on my federal license. Yeah, so I have a federal license for patent law issued by the U.S. government. So I got that going for me. I have not sat for the bar yet. I think I'm going to sit for the bar in July for Texas. I still do patent law at the moment, yes. That is my day job. What are my thoughts on the Capitol riot? I think it's disgusting and horrible, and I certainly hope mass prosecutions will come. I did a whole video about the potential criminal liability earlier. You should check that out. 45 minutes east of Akron. That's where I went to law school. That's really cool. Gina? How to discover the unseemly world of online tea. Nate, the lawyer, recommended this case to me. He said, this case happening. You might want to cover it. So that's a thing that happened. Brandis said she was blocked for not doing anything. Well, I can see you. Is it illegal for my husband to keep stealing my pillow? Well, it might be marital property, so it's kind of his pillow too. Yeah. Do you have an example of other people's backgrounds you like? I mean, I know I kind of liked Legal Eagle's background. I know it's a real background, but I kind of like the aesthetic of it. Um, but and there was a background I've been using that I kind of like, but I'm looking into it. I'm not in a rush. I've got this new lens, and I've bokeh. I've bokeh the shit out of the background, so I'm not sure that I need a green screen, but I've got it there. Will Ty get us how to respond to this? Probably. The judge will probably, yeah. The most likely thing to happen is the judge to rule. Normally you get the initial motion, the response, and the reply, and this is the reply. So like Salty could technically file a reply, but the next thing that probably happen is for the judge to rule. Captain C says, I never used to love the law, but after watching you as well as Emily, I now think about the law aspect first in every situation. Very cool. Do I have a P.O. box? As a matter of fact, I do have a P.O. box. I have to look up my own P.O. box address, though. But I do have a P.O. box. So let me look up my own address, and I will give it to you. And you can send me stuff. Please do not send me bad things. That would be mean. Let's see. As I look up my own address, because I never use it for anything. Mm-hmm. Oh, there's what I need. Yeah, I got it. If you want to send me something, you can send it to this address, which I'm going to put in chat right now. There you go. You can send me something to that address if you're so inclined. Do I have a science degree? Yes, my undergrad is computer science. Yeah. Will I condemn Trump for inciting the mob? I'm not a fan of his rhetoric, that's for damn sure. Wow, you're popular? Well, I do have 1,100 people watching me right now. That's pretty awesome. Now we're doing Q&A. So, why should care if people watch Uncivil Law? He hasn't been negative to her? I don't know. Why should care about stuff, but... Given the effort to date to restrict resisting jurisdiction, would it have been easier to accept at this point? Probably, to be quite honest, but... Can you dismiss with prejudice so it can't be refiled in other states? It won't be dismissed for jurisdiction with prejudice. There's no reason. It's not a decision on the merits. So there would be no decision. There would be no dismissal with prejudice at this point. There can't be because she didn't move to dismiss all the causes of action. So dismissal with prejudice is not possible at this point. Aren't other claims fairly moot because Toddy is a public person? The IIAD and NEID wouldn't be impacted by public person status. The defamation would, and she didn't resist the defamation thing, so it's a pain in the ass. Never SC, but again, New York 416 bill. These are things that I don't know, no one's speaking about. Very concerning. Yeah, that's the one dealing with the forcible quarantining of people en masse in the New York bill. Yeah, I probably need to do something on that at some point. Have you tried peanut butter whiskey? I have not, but that sounds promising. Opinion on In Re Mattia? I don't know what that is. It is fantastic bourbon. I agree. Take a pic of Nick Ricada's background? Maybe. Did I cover Sargon's case? I didn't really cover it as it was happening. That was a miss on my part. I did miss it, and I should have covered it. So that was an unfortunate fail on my part. I'm gonna get 20 things at Halo, maybe. Thanks for doing this, Uncivil. It's great to get multiple perspectives. You're welcome, Miss Bone. Thank you. Salt Lick Barbecue was pretty good. I did enjoy that. I might want to make you something, but I have to know your favorite color. My favorite color is a dark blue, like midnight blue. Yeah, really dark blue is my favorite color. Hey, I recognize your game and you're live from Emily D. Baker. I was. Thank you for recognizing my name. That's awesome. You showed up in my feed, says Yates Network. How goes it? Solid. Excellent. I'm a happy camper. What's my favorite music? Bluegrass. If I'm working out, then I'll listen to something more intense, of course, but bluegrass probably is my favorite. I also like a little bit of lo-fi sometimes when I'm trying to concentrate. My favorite artist is Forrest Day. The fact that they've agreed on discovery, this means that their jurisdiction won't succeed. That seems likely. They do think that. Have I ever had a client as chaotic as KJ? No. How would I defend it if it went forward? Oh, well, I'd just fight the defamation on point. I'd go hardcore public figure. I'd go hardcore underlying truth and just try to smash them on the defamation clause of action. It's one of the reasons I didn't really approve of the motion to dismiss and how it was written. Peanut butter whiskey is bomb. I should cover Chad and Lori Danbell trial. I don't know who those are. Who's Chad and who's Lori Danbell? Let me Google that real fast. Some sort of child death thing. Okay, maybe. Pro marijuana or anti? I'm pro. If this case does go to discovery, can KJ Lair report what's found from it? Sure. Yeah, unless it's protected by a confidentiality agreement or something. So trade secrets, but other than that, yeah, she can report what she hears. If KJ wins jurisdiction, does that mean she actually loses because she switched states and all over? Yeah, that does seem questionable. Being on her turf, though, it makes it a little bit more inconvenient for Toddy. But she appears to have the revenue for it, so I'm not sure how much it matters in the end. You love my BFF. She loves bluegrass, stupid, green ski, and all those. That's cool. Awesome. Well, tell her to hit me up on my Discord. My link for my Discord should be in the description of this title of this video. And if your friend is single and looking for an eligible young lawyer with a sense of humor and witty jokes, holla. Last time I saw $24.99 super chat from Tanya Hey Derpezes. Last time I saw you was in French Laird's video about Bob Murray. That was a fun one to do. Check out the album Home Grass. Is a great band. That's cool. What about Vic or Ahmaud Arbery? What about it? I mean, the Vic case on the Court of Appeals is currently being decided. Should come down relatively soon. I think the Court of Appeals has 3 more months to decide the Vic case. They might take it all. I don't know. But yeah, the Court of Appeals could come down any day with the Vic Mignogna case and deciding those issues. So I'm waiting with that for bated breath to figure out whether or not we can put that to bed. Ahmaud Arbery, that was a very frustrating thing to cover because I argued with some guy about what escape is and is not for several different videos, and it didn't happen. Ween, I missed Ween's super chat. Oh, yeah, I read it. Ween gave me $4.99. Never super chat again. Never super chat, but again, New York 416 bill. These are things no one's speaking about. Yeah, dealing with the potential mass incarceration of people, or incarceration is the wrong term. Mass quarantining of people for health reasons. It's very concerning things. Would love to hear your thoughts instead of KJ. Well, I'm trying to get my thoughts all the time, and I do need to record something about the New York proposal at some point. Tina Watham gave me $4.99. Thanks so much for being fair and non-judgmental. I got your name from watching KJ, believe it or not. You rock. I don't know 100% how to feel about that, but okay. May I inquire further as to what KJ may or may not be saying about me, since I don't watch her content? Just interested for my own edification. Jen became a new member. Thank you very much, Jen. How old am I? I will be 40 years old on Wednesday. I'll be 40 years old on Wednesday. That's how old I am. Ween said, grew up down Holla in Kentucky, raised on bluegrass. If you haven't checked out Billy Strings, you're missing out. New Age Bluegrass, sweet. Liz says, in a blow to 45-year-old serial killers, obsessed moms everywhere, Uncivil just said he doesn't know who the Daybells are. Yeah. You're in your last semester of law school? That's awesome. Hope that works out for you well. Family law is definitely a subject I don't want a piece of at all. I have no interest in family law at all. I wish you all the luck, Harmony. It is just not for me. What Republican would I like to see run against Biden? I mean, we were stuck with Trump, but I'm hoping that Nikki Haley will run in 2024. She's who I like. So we'll see. Lynn Wood is dropping pics on Parler about Hunter Biden. At this point, with all possible respect, I would not trust anything coming from Lynn Wood. I would not consider Lynn Wood to be a reliable source at this point. Uncivil law, hope you didn't dox yourself. I try to avoid it. Snowy said, I'm picky and he's a law nerd and cute. Hit me up on Discord. Discord is the best place to find me. Find the link in the description below. That's where I hang out a lot. Any helpful tips for me graduating law school for family law? Family law, all possible respect, I have zero interest in family law. I never took a family law course. I don't want to know anything about family law. It seems like a world of pain. It's just not for me. I am the wrong person to ask about family law. I don't know family law. I don't want to know family law. That is for someone else. What's my favorite criminal case? I don't know. What law pays lawyers the best? It depends on a lot of different things. I mean, yeah, you need to do your own research, and pay is probably not the only thing to look at. What's my idea on the 25th actually happening? On it actually happening? I don't know, but it seems like a good idea at this point, to be honest. I think it might be good for the party. Abby says, isn't the larger argument claim defamation? Yes. For substance, absolutely. And doesn't the bulk of that become moot because Toddy's a public figure? That goes a long way, yes. So I think Katie has some really interesting answers to come. What are the chances of Lynn Wood and Sidney Powell getting disbarred? Lynn Wood needs to be super disbarred at this point, I think. Am I following Johnny Depp versus Amber Heard? Not really. Am I getting sleepy? No, I just have allergy issues sometimes, and they really cause my eye to itch. I can't stop rubbing it. Yeah, sometimes I get these weird, like, allergic attacks, and it just really hurts for a second. It's partly because I have a light in my eyes, and my eyes are really sensitive to light. But if I don't have it on, the image would not be as good. My eyes are very, very sensitive to light, so having the light right in my eyes is actually quite painful for long periods of time. Yeah. Gabriel said, I was wondering if you saw the teen who was suspended from complaining and cursing about her school and cheer team on Snapchat. I've covered that case. I covered it at both the district court and the court of appeals level. Yeah, I covered that case. It was... What was the name of the girl? I'm not going to remember. K something. But yeah, and the school is asking for cert from the U.S. Supreme Court. They want the U.S. Supreme Court to decide the F cheer, F school, F life case. Why don't I wear sunglasses? Because it would look really freaking weird inside. It would look really, really weird to wear sunglasses indoors. That's why. Yeah, the Supreme Court. Yeah, the school wants to take it to the Supreme Court. Yeah, they asked for certiorari. Yeah, I covered it at both the Court of Appeals level and the District Court level. I covered that case with the Snapchat F chair, F school, F life. Where one of the whole thing is such a drama. It's such a great drama. The one of the kids was not, who was a sophomore, didn't get a spot on cheer varsity, and then this incoming freshman got a spot on cheer, and there was drama over positions. And one of the kids was the child of one of the coaches, and so there was some infighting and blah 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 crap, blah 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 blah. Is Discord like Reddit? It's like Slack, if you're familiar with that, or it's like IRC if you're real old school. More questions? All right, cool. Well, it seems we've reached the end of the chat. For the 1,000 of you who are still here, I hope you enjoyed this time. If you enjoyed this stream, would you be please so kind as to give it a subscribe? I'd really appreciate it. It helps the channel grow and encourages me to do more things like this. And if you have story ideas of more things like this that you'd like, you can suggest them on our Discord or in the description below. I'll take a look at those, and I'd love to cover more stories that will generate more watchers. If you've not done so already, would you hit the little like button on your way out? The like button shows that you love me. I know that you love me, but why don't you show other people how much you love me? Because maybe they don't know about your love, and this is a way for you to publicly proclaim it so that people understand the love, hitting the like button. And if you become a member, you get your name in green, and you get access to batch records, and, I will like you more, and that's all plus. Until later, my friends, I hope all is well. Cheers, and goodbye.